Today in this video we are going to talk about Indian Evidence Act 1872. Actually Indian Evidence Act was enacted on 15/3/1872 by the Parliamentary Act, and it came into effect on 1st September 1872. So the Indian Evidence Act, the very word evidence is a Latin word which came from the evidere. Evidere is a Latin word which means to find out the truth, to come into a conclusion, to reveal the truth. That is the evidere, which comes from the Latin word called evidere. So that is the meaning of Evidence Act. And regarding the structure of structural arrangement of the Evidence Act, it is divided into three parts: part 1, part 2 and part 3. And part 1 consists of section 1 to 55. Totally there are 167 sections are there. Part 1 consists of 1 to 55. Part 2 consists of 56 to 100. Part 3 consists of section 102 to 167. So coming again to the chapters, the part 1 consists of 2 chapters. That is part 1, that is chapter 1 preliminary, section 1 to 4 and 5 to 55. That is chapter 2 relevancy of fact, 5 to 55. Then chapter 3, section 56 to 58, fact need not be proved. That is, the fact itself contains all the truth in it, and so that need not be proved. And the oral evidence, section 59 to 60, that is coming under the chapter 4. Chapter 5 documentary evidence, that is 61 to 90. And chapter 6 exception of oral evidence by documentary evidence, that is section 91 to 100. So up to 100 the part 2 is over. From 101 to 167, that is coming under part 3. So in part 3, the chapter 7 burden of proof usually lies with the prosecution, that is section 101 to 114A in criminal cases. And chapter 8, section 155 to 117, that is estoppel. That is then chapter 9 witnesses, 118 to 134, and chapter 10 135 to 166 examination of witnesses. And last chapter 11, only one section is there, 167, that is improper admission and rejection of evidence. These are all the structural arrangement. And another thing which is very important in this, the law usually is divided into 2 types. One is called the substantive law, and then procedure law. Substantive law or adjective law defines about the punishment to be given, or what are the legal duties and legal rights are there, that is dealt in substantive law. So the substantive law is the Indian Penal Code is substantive law, and the procedure law is describing about the procedures to be adopted to finalize a case. That is what all the investigation, inquiry, the giving of charge sheet, and then the trial, and then finally the coming to the conclusion, then giving the verdict. So many things will be coming side by side. That is under in serial order. Those things are called procedure law. That is including FIR, that is arrest, bail. So many things will come in this criminal procedure code. So these are all the procedures to be adopted for finalizing a case. That is called procedure law. So the Indian Evidence Act is coming under the procedure law. Criminal procedure code is a procedure law. Civil that is civil procedure code, that is also procedure law. So these things as that is regarding the construction of law, we are told about these things. Then we will see about the the first three sections. First, the construction is preamble. Preamble means what is the construction of the act and the amendment of act. Everything will be coming under preamble. Then short title. The title of the act is called Indian Evidence Act 1872. Then extent. It extends to the whole of India except Jammu and Kashmir, and also it extends to the that is military act, and that is Navy Act, and also the Navy, that is Air Act, and also the Military Act. Everything is included. These things, the Indian Evidence Act is applicable for all these things. That is called extent. Extent means to the how much it extent, the extension of the law, applicability of the law. Then the second section is repealment of act. So that is so we are not concerning about the second section. Then the third section is called interpretation class. What are the things in interpretation? Most of the definitions are found in interpretation class. Those things are the fact in issue, then court, fact, then the evidence, and also the documents. All these things are spelled out in section 3. We will see one by one. Interpretation class means the meaning of the Evidence Act. We are going to talk about the fact. What is meant by fact? Fact means anything which is perceivable by the senses is called fact. Suppose by eye we are seeing a thing, an animal or an object, that is a fact. Suppose if we smell it, that is also a fact. If we touch an object, that is also a fact. So what are the things perceived by senses is called fact. And another thing, what are the things that is the mind could take it, that is also it is also called fact. Suppose the man is there, that is the physical corpus body is there, then apart from that he is in drunken mood, that is talk about the mind, what is mind status. Though these two things are included under the facts. What is the, suppose if an ordinary man initiates action, there may not be any problem at all, and it is not coming under the purview of Indian Evidence Act. Suppose if he is in drunken mood, drunken driving, then the question of the Indian Evidence Act comes, that is the fact comes. So that is the what are the things which we perceive and what are things which we perceive in mind, that is coming under the, that is called fact. தமிழில் பொருண்மை என்று சொல்கின்றோம். கண்ணால் பார்க்கக்கூடியது, காதால் கேட்கக்கூடியது, மூக்கால் அந்த வாசனையை நுகர்வது போன்றவைகளெல்லாம் அடங்குவது, that is called the fact. And fact in issue, suppose what is the issue involved in it, whether the fact is involved in that. In Tamil it is called Elivina. What is the fact involved in it? Suppose whether anything wrong happened, that is fact in issue. Like that, the interpretation class we are going to talk about the fact in issue also. And then the evidence. What is meant by evidence? There are two types of evidence. There are lot of evidence, but we are concerning about mainly two types, that is called the oral evidence and documentary evidence. Oral evidence means anything a person see that and he is giving evidence through his oral or mouth, that is oral evidence, வாய்மொழி சான்று. And the documentary evidence, the documents says about the happenings, that is called documentary evidence. And then in that documentary evidence there are primary evidence and secondary evidence is there. Primary evidence means the original document is called primary evidence, and from that we are culling out some Xerox copy or the certificate copy, that is called secondary evidence. That these are all called evidence, சான்றுகள். And then the documentary evidence, maybe there are so many documents are there. Anything written is a document, a lithography is a document, a calligraphy is a statement, or in stone if inscription is there, that is also a statement, that is also a document. And any that is CVD or that is electronical, if it is the document in electronic form, that is also a document. So these are all the things coming under interpretive class. And next we are going to talk about the proved, disproved and not proved. What is meant by proved and what is meant by disproved and not proved. Proved means the court, after considering the matter before it, the court believing it to exist, that is called the proved. When a matter before a court is there, it considered that it exists or it is in existence, that is called proved. Disproved means the court, after considering the matter before it, the court disbelieve it to exist. The court disbelieves it. The existence of a matter or existence of a fact is not there, that is called disproved. When a matter is there and it is brought to the court, then the court thinks that it is not in existence, then that is called disproved. And not proved means neither proved nor disproved. Such of those, that is the court believes after consideration the matter before it, the court disbelieve it or not believing it, that is called not proved. So these words we have to understand for the purpose of understanding the Indian Evidence Act. So proved, disproved and not proved, these things we have to understand it. And these are all coming under the section 3. Next thing, usually in Indian Evidence Act, the judicial proceedings are having the value for Indian Evidence Act. So only what are the judicial matters, that only is taken up for Indian Evidence Act. What is meant by judicial matters, judicial proceedings, that we have to define it. That is when there is a jural relationship between one another, that is one test. So there is a judicial relationship between one and another, that is one objective test, then it is a judicial proceedings. The second thing, functional test, that evidence may be taken legally on oath. All the evidence are taken by means of oath. ஒரு உறுதிமொழி எடுத்துக்கொண்டு, that is we are giving the evidence. So I swear, or I am giving this, and I am by affidavit also they are getting the evidence. That is called the function test. The third thing is called the appreciation test, that is decision making involves the application of judicial mind. So the decision making by the court is always by the application of mind, judicial mind. If these three objects are available, then it is known as judicial proceedings. The other things are not judicial proceedings. Only in judicial proceedings the Indian Evidence Act will take its own course. For other things it will not be applicable. That is another thing. For example, the tribunal cases will not be coming under the Indian Evidence Act. Like that, the departmental proceedings will also will not be coming under the Indian Evidence Act, because what all the applicability in the Indian Evidence Act, these things are not applicable in the case of departmental proceedings, in the case of tribunals. So this Indian Evidence Act is not applicable. So they are not called judicial proceedings. It may be quasi judicial, or it may be administrative, or it may be half of the administrative and half of the judicial, that is quasi judicial. So these things are called only in case of judicial proceedings the Indian Evidence Act will come into effect. Then we are going to talk about the affidavit also. Affidavit means that is anything the promise is given by for an act is called affidavit. Usually the affidavit is done through notary public in a stamped paper of 20 rupees. In that the person who is giving evidence will swear in that this is the truth, or this is the to the mind these are all the facts that is stated in affidavit. So most of the things in Indian Evidence Act, the affidavit should be given for giving evidence and all. That is regarding the affidavit. Then the another thing we are going to talk about case study in this Queen Express versus Tulaja and others on 14th July 1887, Bombay 36. In this case, what the thing is sometimes actually this case is pertains to about the registration of a document. Actually, it is a forged document, and whether the sub-registrar can be the office can be treated as court or not. That is the question in this case. The sub-registrar office is not at all a court. That has been spelled out in this case. And the another one is the Associated Cement Company Limited versus P.N. Sharma in this tribunal. This is also it is not on par with court, because the Indian Evidence Act is not applicable to this. So these are all the cases related to section 3, whether it is coming under the court or not. The court means where the judicial proceedings are going on, and where the judgment is given, and where the inquiry is going on, where the trial is going on, that is the court. But these things, though they may give the verdict on a departmental matter and some quasi judicial matters, for the practical purpose it is not considered as court. The tribunals and then the department proceedings are not at all court. And in Tamil, இந்திய சாட்சியத்திலே மொத்தம் 3 பகுதிகளாக பிரிக்கப்பட்டிருக்கிறது. அந்த 3 பகுதிகளே மொத்தம் 167 செக்ஷன்கள் இருக்கிறது. அவற்றை ஒவ்வொன்றாக சொல்லப்படுகிறது. இதில் முக்கியமாக இன்டர்பிரேஷன் கிளாஸ், அதில் பொருண்மை, ஃபேக்ட் என்றால் பொருண்மை என்ற பெயர். இது ஒன் திங், ஐ ஹவ் சீன் தட், ஐ ஹவ் சீன் எ பர்சன் இஸ் வாக்கிங், ஐ ஹவ் ஸ்மெல்ட் இட், இவைகளெல்லாம் உண்மை என்று இப்போ ஃபேக்ட் என்று சொல்கிறது. ஃபேக்ட் இன் இஷ்யூ தட் இஸ் கனெக்டட் வித் ஏ ஹேஸ் சீன், ஏ கில்டு பி and then C saw it. These are all called fact in the relevancy of facts, and whether A killed B, that has to be decided, that is called fact in issue, that is பொருண்மை என்று சொல்லப்படுகிறது. அடுத்ததாக இதில் ஜுடிஷியல் ப்ரொசீடிங்கில் வருவது பூராக இந்த இந்தியன் எவிடன்ஸ் ஆக்டில் வருகிறது. மற்றவைகளெல்லாம் ஒரு லேபர் டிஸ்பியூட் ஆகட்டும் அல்லது ட்ரிபுனல் ஆகட்டும், அவைகள் கோர்ட் என்று அழைக்கப்படுவதில்லை. இத்துடன் we are closing with this we are closing this Indian Evidence Act 1872.